Thank you so much for joining us today for our webinar about the EB2 National Interest Waiver. My name is Dustin Saldarriaga. I am a senior associate at Scott Legal PC. As I mentioned today, we're going to spend some time talking about the EB2 National Interest Waiver, also called the NIW. This is an underutilized category of green card and one that we've seen used more and more frequently, especially over the last few years, and especially among entrepreneurs. Jiyae will be talking today about how entrepreneurs in particular can benefit from this green card option. Today, we're very fortunate to have Jiyae speaking with us. Jiyae Hwang is a senior associate at our firm, and she has extensive experience preparing EB2 National Interest Waiver applications. Before we get started, a few things to mention. Our firm is a full-service immigration firm, and though we do focus on business immigration, we also handle family immigration matters, humanitarian immigration matters, and really anything touching on U.S. immigration law. So for any questions, please don't hesitate to reach out to us. We'll continue this webinar series by doing at least 2 webinars a month, and we do these on a variety of topics. At the end of this presentation, we'll send you a link where you can sign up for our future webinars. We'll also send you the PowerPoint presentation that you see on your screen, as well as a comprehensive guide on the National Interest Waiver. We'll also share in our follow-up email a link to our YouTube channel. This webinar is being recorded, and we will be posting the full recording to our YouTube channel. On our YouTube channel, you can also find past webinars as well as shorter videos, and these are on a variety of immigration topics as well. So please do check out our YouTube channel. If you have a question during the presentation, please do send it in using either the chat function or the Q&A box on Zoom. I will be monitoring questions, and I'll either share those with Jiyae when the question comes in, or I'll save it for the end. But either way, we do plan to get through all of the questions that come in before the end of the presentation. As I mentioned, this webinar is being recorded and will be posted to our YouTube channel. So without further ado, I will go ahead and pass it off to you, Jiyae.
Thank you so much, Dustin. All right, so let's get started. So first, let's talk about the National Interest Waiver NIW requirements. How do you qualify for a green card under the EB2 NIW category? So as we mentioned, NIW is short for National Interest Waiver, and it is a subset of the EB2 employment-based immigrant petition. And immigrant petition, as you may all know, means this is an application for a green card, U.S. permanent resident status. A green card gives someone the ability to live permanently in the United States and work for any employer or none at all. Having a green card also opens up the pathway to U.S. citizenship. So it is a very valuable benefit that you can get. And that is also a reason why NIW petitions are scrutinized. They go through quite strict scrutiny when being evaluated by USCIS officers. So EB2 NIW, just to speak in more general terms, is a popular choice among individuals who wants to apply for a green card on their own. And this is what I call self-petitioning. And this means you can apply as an individual, whereas normally in other contexts, you would need a U.S. employer, a U.S. company to sponsor you for a green card, which can also take more time because you need to go through the labor certification process, also known as PERM. This can take time. EB1A, the extraordinary ability criteria category, is another green card pathway that allows for self-petitioning. However, EB2 NIW is open to professionals in a variety of stages of their career, whereas the EB1A extraordinary ability is really open to people who have reached the very, very top of their fields, the real cream of the crop. They have decades of experience in their fields. The EB2 NIW is a little bit broader than that. So a more wider variety of professionals who can show that their work will make significant contributions to the industry more broadly can try for a green card. So now let's look a little bit more closely at the eligibility criteria. So first, let's talk about the threshold requirement. And this is true for either the normal EB2 criteria category. If you have an U.S. employer sponsoring you, you also need to meet the EB2 eligibility criteria, but the threshold criteria. But even if you are applying under the NIW pathway, you also need to meet the EB2 category as a threshold matter. So how do you meet this threshold? Either through showing that you have an advanced degree, which is defined as a master's degree or higher and includes a PhD. It can also include an MBA. So if you have an MBA, you are considered to have an advanced degree. Or the equivalent of an advanced degree, right? So let's say you have a bachelor's degree in your field, and let's say your field is biology. You have a bachelor's degree in biology, and after you receive your bachelor's degree, you have accumulated more than 5 years of progressive work experience in biology. And let's say, and by progressive, what do you mean? It means that your duties have changed over time to include more senior duties, more complex duties. And typically your title would have changed, for example, from junior associate to senior associate to partner. That kind of progression is what we're looking for. And your duties would have also changed as well. So if you were assisting, other biologists performing certain functions, as you become more senior, you would perform more complicated and more senior level duties. And these types of progressions would be evidenced by letters that you get from your prior employers on company letterhead signed by the appropriate official. And that is how you would prove that you have this 5-year experience or more. Now, when I say bachelor's degree, it needs to either be a US bachelor's degree, or if you have a foreign bachelor's degree, and this is also true for a master's degree, you do need educational equivalency certification from an agency in the US that confirms that the degree that you have from a foreign country is actually equivalent to either a US bachelor's degree or a US master's degree. So that is something that you should take note of. There is another way, if you do not have the bachelor's, if you don't have the 5 years, if you don't have the master's, there's another way you can meet the EB2 threshold, and that is through showing that you have exceptional ability in the sciences, arts, or business. And I just wanted to make sure that people understand that if you do have an advanced degree, there is no need to go and make the exceptional ability argument. The exceptional ability argument is only if you cannot meet, it's only relevant if you cannot meet the threshold category through an advanced degree. Usually the advanced degree is the more straightforward way to meet the EB2 threshold. So how do you show that you have exceptional ability in the sciences, arts, or business? So there's a two-part test. So the first test is that you show evidence under 3 out of 7 criteria or more. And this includes 10 years of experience in your field, any related degree or diploma that you have. It doesn't need to be a bachelor's. It could be an associate's degree that is related to your field of work, licenses to practice in your profession, proof that you earn higher salary than others, and membership in professional associations, but also, and this is the most important part, is show that you have earned recognition from your peers in your field by your contributions to the industry or the field that you're working in. So this can be in the form of awards. This can be in the form of, garnered a lot of citations for your papers or things like that, or media features of you and or your work. So those kinds of evidences can show that you have earned reputation as a leader in your field by your contributions to your field that is original. That is the kind of evidence that you are looking for to prove that you are someone who is operating well above, significantly above what is ordinarily encountered in your field of expertise. Now, so let's say that you have already met this EB2 threshold criteria. Now, the next part of preparing for an NIW application is demonstrating that you meet the 3-part matter of Danazar test on, qualifying for a national interest waiver of the labor certification requirement. So this part is important because if you don't meet the NIW criteria, the 3-part matter of Danazar test, then really your option is to get, a sponsor from a US company and go through the ordinary labor certification process. The NIW allows you to be exempt from that time-consuming process, and you need to show that you deserve to be exempt from it. And that is how, and the 3-part the three-prong test is how you would show that you deserve to be exempt. So what are the three prongs? First category, prove that your proposed endeavor in the United States have both substantial merit and national importance. Now, what does it mean to have substantial merit and national importance? Substantial merit can be proven in a variety of areas. It can be agriculture, it can be science, it can be literature, it can be, sociology. Generally, what you want to show is that your work would offer benefits to your field in a broad way. And this also ties into national importance and how the government defines national importance. National importance is judged by what the case law says is prospective impact. And what does prospective impact mean? This means if, let's think of two scenarios. The first scenario is you are an engineer and you provide great services to your employer. You do what the employer tells you to do and you help make products or software. That is a localized impact. Your work benefits your immediate employer. Now, if benefits of your work are limited to that, then that is a difficult case for finding national importance, because the government is looking for broader impact to the field as a whole or to the economy more broadly. So let's think of another scenario. Let's say you are an entrepreneur and you developed a new way of designing a mining equipment that shortens the time related to exploration to half, and you are going to patent this this product, and the patent is going to be published, and also you're going to commercialize this product so that many different mining companies in the United States can use this product and curtail their production time to half. Now, that is a broad industry-wide impact. You are presenting an innovation in the field that hasn't been there before, and it improves the processes and the common practices that the industry currently has by offering a new way to do things that really improves productivity as a whole for the industry. So that is kind of a stronger case, in my opinion, for qualifying under the National Interest Waiver. National importance criteria for the NIW. The prospective impact of the individual's work should be broad. Now then, what is the second criteria for the National Interest Waiver? That you yourself are well positioned to advance the proposed endeavor. So the first criteria, national importance, was really the focus was about what the individual was planning to do in the United States. The second criteria, well positioned, is really focusing on the individual themselves. What is their experience, education, skills? What have they done in the past that really positions them well to do this work that can have these broad impacts? So to meet the well-positioned criteria, you really want to show that you have had a record of success in previous related projects that is similar to what you're planning to do. So let's say you are a researcher and you're planning to research a new drug for a particular disease, right? You want to show that you have performed medical research before, and it doesn't need to be on the exact topic that you're planning to research in the future, but it really needs to be in the same field so that you can show that you have performed research before and that research has been cited by others, or that the research has, receive government funding, or that somehow your work has resulted in benefits to the field already. So that really supports the argument that your future work will also benefit the industry more broadly. So the thing to consider is that the second criteria focuses on the individual themselves and their record of success. Now, the third criteria, there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. Now, there are a variety of ways to argue the third prong, and really what we do is to emphasize the broad benefits, similar to what we would do in meeting the first prong. We would talk about how your work not only benefits your immediate employer, but also results in progress in the industry as a whole. So there are outsized benefits of letting you come and work here rather than saving the spot for, another US worker with minimum qualifications. So that would be one argument we would use. Another argument is that you yourself have very specific skills that are not replaceable by another worker with similar credentials, just because, the proposed endeavor that you are doing is so complex. If going back to the example that I was saying, if you're developing that, mining equipment, someone would need to have very specific knowledge and expertise in that area to really succeed in offering that innovation to the field as a whole. And so we can really hone in on your particular experiences and your unique skills that cannot easily be replaced. So that's another way we can argue the third prong. Another argument that entrepreneurs can in particular benefit from is that, it is impractical for entrepreneurs to get labor certification from a company because they actually own the company. So that's one argument that strongly, advocates for entrepreneurs, because they don't have the option to go through the ordinary labor certification process through employer sponsorship. Another argument entrepreneurs can make is that in many cases, entrepreneurs not only contribute tax revenues to local and regional governments and federal governments through their business activities, they also create U.S. jobs. And one of the reasons why Congress has the labor certification process in place is to protect the U.S. labor market supply. But if an entrepreneur is actually creating more jobs and creating dozens of more jobs in the process, then there is a countervailing benefit to having the U.S., having the entrepreneur come into the U.S. and create these jobs, which, serves Congress's intent in a better way than, saving one U.S. labor spot through the labor certification process. So that is another very powerful argument that entrepreneurs can benefit from when they're arguing the third prong.
So Jiyae, thank you. We did get a question that is relevant to this slide. As a Juris Doctor JD degree, is a Juris Doctor considered an advanced degree? How about a Master of Laws, an LLM?
Yeah, so happy to answer that question. A Juris Doctor degree is considered an advanced degree, and an LLM would also be considered an advanced degree. And the reasoning behind that is that you need a bachelor's in order to gain admission to a JD program or an LLM program. So that is considered an advanced degree because you already need to have a bachelor's in order to be eligible to start that program. So for example, an MD, medical doctor degree, also qualifies as an advanced degree because you need a bachelor's in order to start that program.
Great, thank you.
All right, so let's move on and maybe discuss a little bit about how the National Interest Waiver can be used for entrepreneurs. So changes in the NIW criteria really made it more friendlier to entrepreneurs and made it easier for entrepreneurs to apply. And there are several ways in which the law changed to allow that. So previous case law really focused on what was the national scope of the endeavor. So which means sometimes the government would deny petitions if someone's endeavor was only focused on one geographic area. However, this case law has changed now. So so even if an entrepreneur's business project only covers one geographic area, and let's consider an example. Let's say there's an entrepreneur who set up a factory in Ohio, locally producing and distributing innovative products that, let's say it reduces waste and makes buildings more energy efficient. Let's consider that example. And all of the facilities and the buildings can be limited to the the Ohio facilities in that example that I just mentioned, but the endeavor could still have national importance. And one of the ways the endeavor could be seen to have national importance is that the company is offering an innovation to the industry as a whole and can result in follow-on endeavors by other companies that are seeing the success of what this front runner is doing. And so we can argue that there would be a spillover effect that would result in progressing the industry as a whole. And that can be one basis to find national importance, even if the physical scope of the endeavor is limited to Ohio. The business itself only hires people in Ohio, only manufacturers in Ohio. It can deliver, and publish its findings in other areas, but the geographic scope of the endeavor is not important anymore. So that's one way that the case law has become more friendlier to entrepreneurs. Now, the second consideration that really works for the government is that the argument works that entrepreneurs are self-employed, which means they typically have ownership in their own companies. And so they often cannot practically benefit from the ordinary labor certification process. And that is a consideration that the case law explicitly discusses now and says the NIW could be a good solution and fill this gap because entrepreneurs otherwise cannot qualify for a green card. And that is something that the government now explicitly recognizes. And we can use that in the arguments to, for example, support the third prong of the national interest waiver test, as I mentioned before. Now let's think about another point. Entrepreneurial work can lead to an NIW, and the planned venture does not need to ultimately succeed as long as the applicant can show it is more likely than not to succeed. And that is not even true. As long as the applicant shows a plausible plan, that is supported adequately by third-party evidence, and you can show that there is traction for your work. So obviously the business plan should not be speculative, and you should already have a track record of success and already be able and ideally be able to present enough industry interest in your work to show that your project is not speculative. But really, the government really understands that business endeavors can fail, and business endeavors do not, always go to plan. So you're not really expected to prove that your endeavor will succeed, right? So that is not how to qualify for an NIW. You don't need to prove that your endeavor will, 50% or more, your endeavor will succeed, because no one can predict the future. But the real important question is, what is the prospective impact of your work, right? So if your venture is successful, what can happen? And does this benefit extend sufficiently beyond your immediate clients, but result in progressing the industry as a whole and, introduce innovations that can really progress the country? I think that's kind of the core of what the NIW is looking for. So yeah, the thing to understand here is that the government knows that the nature of startups is that some startups fail and some startups may end up not, going forward. But the important thing is, what is the prospective impact of your work? All right, so let's shift gears a little bit, and we can consider, some logistical factors on considerations when you're moving from a non-immigrant visa to an NIW. And the NIW is a petition for a green card. So that is very important to know what you're getting into with regards to if you need to prove non-immigrant intent, for example, having an immigrant visa filed immigrant petition filed can complicate things. So let's first talk about timing. How long does it take to get an answer on your national interest waiver petition? So now, very good news for all applicants, premium processing is available for NIW applications. So a government action, which can be a decision and hopefully an approval, or it can be an RFE, request for evidence, or an NOID, very rare, but a notice of intent to deny if the government really thinks you don't qualify. So either of these three things can happen within 45 days. And we have also seen, although the processing standard is 45 days, we have seen very quick approvals for the cases that we filed this year. We have seen an approval in 7 days, and I believe that was the fastest approval that we've got 7 days from filing the NIW petition. So that was quite surprising. What about regular processing? If you file for regular processing and don't pay extra for the premium processing, usually it means your I-140, which is, the petition for eligibility for a green card under the NIW criteria. The I-140 may be pending for more than a year, about a year. That's the average, I would say. And after you have the approval on the I-140, you can move on to, either to adjust status or to apply in your home country for immigrant visa processing through your home country consulate. You can choose to do that if you're in the United States. If not, you would only be able to, go through the immigrant visa processing through your consulate. And this is also assuming that your priority dates are current at that time. So if all of these things line up, I would say probably another year from there to process the green card. So this can considerably lengthen the timeline from filing to, when you have the green card in hand. That can very often be a very prolonged process. And now let's talk about your underlying visa status. So let's say you are already on a non-immigrant visa that does not allow for dual intent. Now, visas that do allow for dual intent include H-1Bs and Ls, right? So if you're on H-1B and if you're on an L, it is fine if you have an immigrant visa processing in the background. You can even file an I-485, and that is fine because those visas are explicitly you are explicitly permitted to have immigrant intent under those visas that allow for dual intent. However, many visas don't allow for the holder to have an immigrant intent. So, and one example of this is a TN visa. The TN visa is very strictly scrutinized for immigrant intent. And if the government thinks that you intend to adjust status to a green card holder while you're in the United States, that can be the basis for denying your TN visa. And that is true for other visas, such as the F1 visa for a student, for example, J1 visa for a researcher. Things like that, even the E2 visa, right? E1, E2, E3, etc., right? So let's say you have your E2 visa right now, and let's say your E2 visa is expiring soon. As a strategy matter, maybe you want to wait to file your I-140 until you have the new E2 visa for another 5 years. And then during that time, maybe you can file for an I-140 and try to adjust status to a green card holder within that period while you don't need to renew your E2 visa. Because, and this is also a strategy consideration of, do you need an actual visa stamp from a consulate, or can you continue extending the visa from extending your status from USCIS? Because if you're, talking to a consular officer at a consulate abroad and you need an actual visa stamp, then I would say it is a little bit more risky if you have an immigrant visa petition filed, immigrant petition filed, the I-140. Even at the I-140 stage, it can pose a risk to, at the consular interview when you're applying for a non-immigrant visa, which really makes it important for you to consider all of these strategy, moving parts in your strategy before you apply for the NIW. Now, so as I kind of alluded to before, the application process is really in 2 steps. So the first step is the I-140, which is the underlying petition for eligibility for a green card under the EB2 NIW category. That's the bulk of your petition. So you would submit the form I-140 with all of the proof of your qualifications, including proof of your record of success, proof of your proposed endeavor, expert letters, talking about how your work stands to influence the field in a positive way, and what are the key accomplishments you have made in the past. So that packet of information will be submitted at the I-140 stage. And based on that information, the government, the USCIS, will make a decision. Okay, does this person qualify for a green card under the EB2 NIW program? So you would get the approval. Let's say you get the approval of the I-140. The next step is the actual application for the green card. And And as I mentioned before, there are two ways that you can apply for a green card. If you're already in the United States on a different status and your priority dates are current for your category, you can file what is called an I-485, the adjustment of status application. And at the end of that, you will get the green card. Well, hopefully. You can also file the immigrant visa application through a foreign country consulate. So which means you would file the DS-260, and there are different documents that you need to prepare, but you would send them to your home country consulate. We'll send them to the National Visa Center, and that's going to be processed through your home country consulate. And what you would do is to attend an immigrant visa interview at your foreign country at your home country consulate. And after that, you will get an immigrant visa stamp. And once you have the immigrant visa stamp in your passport, you would make the landing to the United States, and your green card will be mailed to you. So that's the other way you can get the green card. Now, the important consideration here, and this didn't used to be an issue, but it is now an issue, is the category current, the priority dates current? And what do I mean when I say priority dates? What is being current? What does that mean? That means every year there are a limited number of immigrant visas / green cards available. And every year there could be more applicants than there are the number of immigrant visas. Now, usually before the end of 2022, the EB2 category has always been current for most countries, other than certain countries such as India or China, which have always been backlogged. But for all other countries, the EB2 category has always been current, which means there were more visas available than there were people who were applying for the visas. However, since November 2022, the category has started to become backlogged, which means now there are more people applying for immigrant visas, green cards, than there are green cards available. So what does this mean for people practically? So every month, the Department of State publishes what is called a visa bulletin. And you would read the visa bulletin and go down to your particular category and see what is the priority date written for that particular category. And by way of example, in August, the priority date for the EB2 NIW category for most countries around the world was April 1st, 2022. What does that mean? If you file I-140 right now, your priority date will be the date that USCIS receives your petition. So let's say you mail it off today. Let's say the USCIS receives it on August 17. Your priority date is going to be 2023, August 17. And you will not be able to move forward with the green card application, even if you received, even if you were approved for the I-140 later, because right now, only people who have filed their applications before the priority date that is written in the visa bulletin can apply and move forward to the second stage, which is the application for the green card, such that, if the date says 2022 April 1st, only people whose priority dates are before preceding April 1st, 2022 can move on to apply for a green card, which means, you could be looking at many months of waiting before the date catches up to you. Let's say if you file the NIW application now, you could be waiting many months until this category becomes current again. Now, every October, there is a fresh, new supply of visas available because, USCIS follows the fiscal calendar. So October is when it resets. Okay, so we do expect that things will start to progress a little faster once a new batch of visas are available in October this year. But the way that the government acts, you can never predict exactly what's going to happen. So definitely it is wise to consider that this could be a prolonged process, especially because the priority dates are retrogressed right now. Okay, so let's now talk a little bit about pros and cons of adjusting status in the United States versus consular processing. So as I mentioned before, you can file the I-485 if you're already in the United States on a different status and your priority date is current. The benefit of filing the I-485 adjustment of status is that once you file the I-485, you're able to continue staying in the United States while the immigrant, while the green card application is processing, which means even if you run out of status, as long as you file the I-485 before your current status ended, you can continue living in the United States. You can apply for an employment authorization card, work for anyone you want. You can apply for advanced parole that will allow you to travel in and out of the country. But before you have the advanced parole document, if you leave the country while your I-485 is pending, that will result in abandoning your application. So that is the main drawback of going through the I-485 process, is that you need to you could be stuck in the United States for a little bit while you receive before you receive your travel authorization. Otherwise, if you leave the country, you abandon the I-485 and you need to start all over again. Whereas if you choose consular processing, this means you would travel abroad to attend your immigrant interview. Or if you're already living in if you're not already living in the United States, the only choice you have is to go through consular processing and apply for an immigrant visa at your home country. So the disadvantage of that would be if you want to be in the United States and work and live, you need a separate, independent status from whatever is going on to be able to do that. So you're not really guaranteed a way to continue living in the United States after your I-140 is filed.
So Jiyae, just to explicitly go back to what you were talking about regarding the category being current.
Sure.
If someone is living in the US, can they apply concurrently even if their date is not current?
So the answer is no. If their date is not current, concurrent filing the I-485 is not possible, unfortunately.
Okay, thank you, Jiyae.
No problem. There are quite a lot of other questions that came up. Let's see if we can.
There are. Yeah, I'm saving a few of them for the end.
Okay, no problem. So we can move on. All right, 2022 updated guidelines for STEM and entrepreneurs. So we have seen a couple of policy updates that gives applicants a better idea of what the government is looking for when they say national importance. What do they think is in the national interest? And naturally, what is defined as in the national interest changes with different administrations, different needs of the government at any given time. So the 2022 updated guidelines really give us a sense of what the government is currently interested in terms of national interest. So with regards to the STEM specific guidelines, one very useful resource is to look at the critical and emerging technologies list, right? And that is a list published by the government talking about specific fields that the government is really focusing on in terms of being important for national security and things like that. So to the extent your proposed endeavor is related to those critical technologies, you could have a leg up in your application for an NIW. And now I'm just going to read out some of the examples of what is a critical and emerging technology. This includes advanced computing, engineering materials, manufacturing, sensing technologies, aero engine, airplane technologies, agricultural technologies, AI, artificial intelligence, autonomous systems, biotechnologies, communicating and networking technology such as 5G networks and things like that, data science and storage, medical and public health technology, quantum science, semiconductors, space technology. So those are some of the areas that are listed in the CNET list. It is worth looking that up and seeing if your work is related to any of these. That could give your petition a leg up. Now let's talk a little bit about entrepreneur-specific guidelines. So another one of the priorities, governmental priorities that we see, especially after 2022, is the government wants to encourage entrepreneurs to, continue creating jobs in the United States, continue contributing to the United States economy by fostering innovation in many fields, right? So the guidelines really made it more specific on what kinds of alternative forms of evidence entrepreneurs could present to persuade the government of, that they meet those prongs, such as national importance, substantial merit, and well-positioned. So let's look at first national importance. So if you can prove that, your work has received significant media attention, and it doesn't need to be, talking about you as a person. If your startup, for example, has received that attention, you can use those as evidences that your work has national importance, because your work is offering something that is that can really impact the field more broadly, that can really spark progress in your field. Awards or grants from government entities can really be a powerful evidence that your work is within the national interest. What about letters from third-party industry actors? And the identity of these actors is very important. So if those letters are coming from a venture capital firm, for example, an established institutional venture capital firm that has experience evaluating a large number of potential startups, but somehow think that your startup is really special and worthy of investment and really has promising potential and things like that, you can get a letter from the VC firm talking to those potential benefits. Similarly, letters from government agencies that cover the field. So if you are working in agriculture and you have a very innovative business, and if you can get a letter of support from the USDA, for example, an official from the USDA, that can really help give your petition a leg up. What about financials of your business? If you have evidence of revenue generation and growth and job creation, and if you can show that it is of a very significant scale, you can show, for example, a valuation of your company, or you can show audited financials, such as profit and loss statements, or you can show recent tax returns that show how much revenue your company is making and how much tax revenues are you contributing to. The larger those benefits are, the more meritorious the government is going to think your business is. What about well-positioned? So an entrepreneur can prove that they are well positioned to continue running their business, which has such transformative potential to the industry, by showing that they have ownership and they are acting in a critical role in the U.S. entity. If you can prove that you have led the company to gain admission to incubators or accelerators that are well known in the industry, such as Y Combinator, Techstars, or things like that, that in itself can also serve as independent validation of the transformative potential of your business. That can be very positive for your petition. Media attention on you or the company, and also track record of success that can be shown by either letters from third parties, as I mentioned before, or by tax returns that show significant revenue growth and hiring growth during the time you are running your company. That can also help show that you yourself are well positioned to continue running your company. All right, so then let's talk a little bit about how an NIW submission is built. What are the supporting evidence that is commonly included in an NIW submission? So the first proof to consider is, do you meet the threshold requirement, right? And if you meet the threshold requirement through having an advanced degree, such as a JD or an MD, for example, you would include a copy of your diploma. You would also include a copy of your transcript to show that you meet the threshold by an advanced degree. If you are also meeting the the criteria by showing that you have the equivalent of an advanced degree by having a bachelor's and a combination of the bachelor with 5 or more years of progressive work experience in your field. As I mentioned before, it is necessary to get employment confirmation letters from previous employers on company letterhead describing what your duties were, how long you worked there, what were the terms of employment, and how did your duties change over time, such that the duties are progressing in nature, becoming more senior, more complex as time goes on. So that is another way. That is another evidence that you need to prepare if you're meeting the threshold that way. If you are meeting the threshold through showing exceptional ability rather than through showing that you have an advanced degree, you do need to prepare the evidence as required under the regulations, at least 3 out of 7 criteria, such as, if it's 10 years of work experience, you would want to get proof of that through employment letters, just like I mentioned before. If if you have a diploma that is related to your area of work, you would provide a copy of that diploma and a transcript. If you're presenting evidence that you have a higher salary than others, you would want to present proof of that salary with comparable data that you gained from research on other databases that shows the average for that particular profession in your particular area. So that exercise will have to be done. So you will actually have to present all of those evidences as in addition to preparing an argument that these facts really position you as someone who is operating at a level that is significantly above what is ordinarily encountered. So now let's say we have prepared the evidence meeting the threshold requirement. Now, the second step is to show that your case meets all 3 prongs of the matter of Danisar NIW test, which is the first prong, that your proposed endeavor has substantial merit and national importance. The second prong, that you yourself are well positioned to advance the endeavor. And third, on balance, it will be beneficial to the United States to exempt you from the requirements of a labor certification. So for national importance, some of the things that you can consider adding is news articles, academic papers, market research. Those are supporting evidences that can help you build a narrative of why your contributions to the field is needed, why is there a gap in the industry that only you can fill, and what kinds of positive impact can you expect from your work in that particular field. So let's say, as an example, if you are someone who develops programs for the welfare of veterans, you could pull government announcements, market research, and industry reports talking about how there are these gaps in service provision for veterans and how there are urgent priorities for the government to really improve programming for veterans in ABC areas. And you can combine that with evidence that you will be doing work filling these gaps, right? That the industry urgently needs, that the government urgently needs for the society. That is one way you can build a narrative for national importance. Now let's talk a little bit about expert letters. What roles can expert letters play? Expert letters are very important for NIW petition because they contextualize the information and really help build a narrative in a comprehensible way to the person who is reviewing your application. These letters can be used to help build the argument for why your work is needed in the industry and what are the prospective impacts that can be expected from your work. So for example, the expert letters can be used to provide more detail about what are the challenges that the industry is having with regards to, let's say veterans welfare. What are the specific areas that really need intervention? And link it with your work. Like, what do you actually propose to do? And what programs do you what programs are you developing that can effectively meet those gaps, and why is it needed, and what are the positive impacts that can be expected from your particular project. And the expert letters can really help you expand on that, because some of the government announcement and things like that could be not really specific to your work, your personal work, but the expert letters can really fill in that gap by really talking about what you are proposing to do, and what are the impacts that are specific to your particular project. In that way, expert letters can really be a powerful tool to meet the national importance requirement, also meet the well-positioned requirement. Now, what about your record of success? So your record of success to meet the well-positioned requirement, you can typically you would include your resume, and proof of degrees, relevant degrees in those academic programs. And really, you can gather proof of what are the achievements that you've already made in your field. What are the accomplishments, contributions to your field that you have made, right? This can be proven by such as copies of awards, patents published, publication of patents can really be evidence of a wider impact, because other people will look at those patents when they're doing their own literature review. And those patents are disseminated to other experts in the field and cited by other experts in the field as well when they're doing their own research and doing their own technological development. So in that way, those kinds of public-facing work product that you can show, that can really help position you as someone who is well positioned to make an impact in your field. Presentations at conferences, that is usually a very helpful form of evidence that I encourage clients to include if they have made any presentations. Similarly to the patents, presentations at conferences mean that you have shared your original insights to other experts in your field, which can support a finding of a broader impact to your industry rather than just benefiting your immediate clients. Evidence of industry or media recognition on either yourself or some of the projects that you have led. So to go back to the hypothetical example about the person who's developing programs for veterans, if that person has led, the management of a program, like a particular event that has received a lot of media attention, has appeared on, newspapers and interviews talking about those, how this program made an impact in veterans' welfare. All of these evidences are relevant in building the narrative of, broad impact to your field, and can really position you as a leading expert in your field that has this record of success to meet the well-positioned requirement. So we highly encourage the client to really start collecting all of these evidences if they are looking to prepare an NIW application in the future. Now let's talk a little bit about entrepreneurs. So specific to entrepreneurs, evidence can also include contracts with, business partners that show traction in their particular business project. And if those contracts are with, prestigious entities in the field, such as, and these contracts can also take the form of stock purchase agreements where you receive outside investment from a prestigious VC firm. That can also be included in your file as evidence that there has been significant industry interest in your particular project. Letters of intent from government entities, for example, if they are interested in collaborating with your company, or letters of intent by other well-known entities in the industry that can show that, that your project has a potential to offer to the industry as a whole, and that significant public and industry interest has already been secured. That can really help substantiate your proposed endeavor.
Great. So Jiyae, we have received a number of questions while we're talking about the submission piece.
Sure
Does
thing.
an applicant need to submit their personal bank account statement?
Not really. Well, it will really depend on the role that the bank statement would play. So let's say, for example, if you're trying to prove that you are founding a company in the United States and you want to show that you have substantial startup capital to do so, I can see a need of, making a business bank account and putting money into that bank account and showing that bank account, to prove that you have sufficient startup capital to make your project a reality. But otherwise, submitting your personal bank account is not a usual requirement for an NIW petition. So yeah, it'll definitely be fact specific, but usually no, I wouldn't say it's required.
Great. And to talk about the threshold requirement, can someone apply under both advanced degree and exceptional ability?
Yes, they can do that. The argument would be, they would not only have the advanced degree, but they would also separately meet the criteria for exceptional ability. I don't normally find the need to argue exceptional ability if the person already has an advanced degree. And I think some aspects of exceptional ability can be folded in when you're, for example, building your narrative about well-positioned. So you would talk about the significant contributions you've made to the industry, which is one criteria in exceptional ability, but you don't need to go through the other criteria in the exceptional ability if you already meet the threshold through other means. So I don't believe it's necessary. I think it is certainly possible for someone to argue both. But if you, usually I would say it is the simplest way to meet the threshold through advanced degree.
Perfect. And is an application stronger if someone's already in the US, say on an L visa, versus if they're applying from abroad?
I wouldn't say there is a difference. It really would depend on what the person has done in their home country. For example, if they are an influential figure in their home country in that industry and have and can prove that their work has succeeded in industry-wide changes, progresses, and if you have sufficient evidence of those things, you don't need to have a history in the United States to be approved for the NIW green card. Now, practically, if you're already in the United States and have contacts such that if you have a project in mind and if you can get more industry traction that way, and if you can build a more of a network there while you're in the United States, that could help substantiate your proposed endeavor. And the thing about the proposed endeavor is that it cannot be completely speculative, right? So in that way, being in the United States could give you some advantage. But as a general matter, I've seen plenty of cases where the person has never set foot in the United States, but was able to successfully apply and be approved for an NIW. So it really depends on what that person is doing and what is their influence, what is the level of their influence in the industry.
Perfect. And there was a question about the green card being current. So if someone's here on, say, H-1B, they file an I-140 concurrently with an I-485, but without premium processing, they want to confirm that it would take about 1 year. Is that correct?
Yeah. So you would only be able to file the I-140 concurrently with your I-485 if the priority dates are current at the time you apply, right? So so if you had, right now the EB2 criteria, the EB2 category is not current. So if you're applying now, you cannot concurrently apply with your I-485. So that is something you can only do at the month when the priority date is, it says current, it says a C on the table, right? With regards to the premium processing time, you can certainly get the I-140 approved before your I-485 is approved, because the I-485, there is no premium processing option for the I-485. So I would say, give or take a year for the I-485 portion. And for the I-140, if you opt for the premium processing option, you would get an answer within 45 days.
Perfect. Thank you. So there were a number of questions that are kind of specific to people's circumstances. So I would just start by saying, we're in this webinar, we're not going to talk about specific circumstances. Feel free to schedule a consultation to do that. But I will try to reframe a few in more general terms. So there has been a lot of discussion about pilots trying to get NIWs. Jiyae, what would be a good pilot NIW versus a bad pilot NIW?
Right. So I can start with a bad pilot NIW. So a bad pilot NIW is this. I'm a pilot. I fly, airplanes for United Airlines, and I want to continue flying planes for United Airlines as one pilot. And the argument is that the United States has a shortage of pilots, so I should be approved for a green card. That's not going to work. And if there's a lawyer that says that is going to work, that lawyer is trying to get your money. So beware of that. A good NIW case for a pilot is if you do something more than that and affect the piloting industry more broadly. So let's say you are an entrepreneur and you are developing a software that can streamline the process of training pilots, and you have already developed this software in your home country, and you have already commercialized this software to like 10,000 companies, and it has had really good traction. And you want to bring this initiative to the United States so that US pilot training academies can use that software to train pilots in a more efficient way, which can really help solve the pilot shortage issue. Now that you are doing something new to the industry and you are offering some innovation that the piloting field didn't have before, I think that has a stronger argument for the NIW and would have a better traction than just as compared to a case where you're saying, I'm a pilot, I would like to fly planes in the United States, and I'm one pilot, and the government is 100% going to come back and say, well, it is true that the US has a shortage of pilots, but what is having one extra pilot going to do to solve that problem?
Great, that's helpful. So you spoke a little bit about STEM and the STEM fields receiving, being explicitly listed and receiving some kind of an advantage. So what does that mean for those who are not in the STEM field, say lawyers? Can lawyers still be deemed to be operating in the national interest?
So the answer is, well, it depends, right? But as a categorical matter, yes, lawyers can be approved for an NIW. And the key to this is, what is the prospective impact of your work? So if the impact of your work is just to provide great services to your clients, the impact is limited to your immediate circle. And if that's the case, it's going to be a difficult case. In order to be approved for the NIW, you need to be offering something broader to the field. Let's say you are, a legal scholar in addition to being a lawyer. Let's say you regularly appear in conferences in your field. Let's say you are a very respected scholar on a particular aspect of contract law, and you're invited to these conferences to speak on that particular aspect of contract law because that's something that other lawyers had not thought of before. So let's say you have made those presentations regularly. Let's say you've published some articles in academic legal journals related to that particular area that you are well known for. I think that is a better case for a lawyer being approved for an NIW, because not only can you say you're doing great services to your clients, but you can also say you're offering innovations to your field as a whole, and your work is being disseminated to other experts, other lawyers, and affecting the work that they do in a better way, and filling some gap in the industry with your expertise. I think that is definitely a better angle to go.
Perfect. So we are over time. I want to thank you, Jiyae. I want to thank those of you on the call who sent in great questions. Several people have asked, if I'm interested, what are the next steps? Please visit our website. We do have a link, Scott Legal PC. You can schedule a consultation. That is a wonderful next step. It can be a 30-minute consultation, or just send us an email through the link on our website, and we can send you our engagement letter, which details the process as well as the costs, and we can take it from there. So please don't hesitate to reach out. We do hope this presentation was helpful, and we hope to see you on future presentations. Thank you so much, Jiyae, and thank you to everyone for participating.
Thank you, Dustin. Thank you, everyone.